Good morning. My name is Yasinur Rahman, student ID BSA 2013. Today we're gonna present a case ESIC versus Lewicki 2017. It's a group presentation, and this is our 5 members. And first of all, I'll go through the introduction process. In the introduction, there are 4 facts on this case. The first one is a responsible entity of a management investment scheme was Australian Property Custodian Holdings Limited. The second one, the 4 directors of APCHL decided that the constitution of the fund must be amended, and the decision is taken on 19 July 2006. The third one, on 22nd August 2006, the directors of APCHL decided that the amendment constitution must be lodged to ASIC. The fourth one, after the lodgement of the constitution, APCHL has listed the trust on the ASX, and fees of listing at 33 million was given to APCHL HL for the fund. Secondly, I'll go. There are some in this case. There are some duties which were violated by the directors, and those 3 are breach of section 601 FD of the Corporation Act 2001, breach of section 208 of the Corporation Act 2001, breach of section 601 FC of the Corporation Act 2001, and my fellow the fellow members, they will be going through this in a brief. Now I'll pass it to Nirmal to go through the next section.
Thank you, my friend. My name is Nirmal Aryal. Today I'm gonna talk about the decision of the court. The court allowed the appeal and dismissed the cross appeal. And second, the trial judge order on 2nd December 2014 in the proceed BID 594 of 2012 are set aside. The cost of the defendants at the trial proceeding are paid by the first respondent, including the reserved cost. And the fourth one is the cost of appeal and the cross appeals of the appellant is paid by the first and the second respondents. And the cost includes reserved cost and any other cost. Now the my rest of the topic regarding the sections, my friend Osti gonna talk about it.
Hi, this is Asis Wosti, student ID EPM 2025, and I'm gonna present on the reasons for the decision. First of all, I would like to thank Nirmal for passing me down the chance to speak on reasons for the decision. So, according to the trial code, there are like 2 sections on which ESIC has appealed for the court. The first one is contravention of statutory duties under section 601 FT 1B, and the next one is contravention of section 208 of the Act. So the ASIC made an appeal on the trial court, which the decision was aggrieved by the trial court, and on the appeal, the decision of the trial judge was overturned by Greenwood, Middleton, and Foster JSA. Now I'm gonna talk about contravention of section 601 FC. According on the contravention of section 601 FC, the listing fees that is granted was authorized by the amended constitutions. The directors are of the good belief that the amendments that are made are valid. The last one is they have no reasons to believe that reconsiderations to be made to the said amendments. So now my friend is gonna read out the section. Now my fellow friend Pritpal is gonna do the contravention of section 601 FT. I would like to pass it to him. Thank you.
Hello, this is Pritpal Singh, and I would like to talk about the contravention of section 61 FT. Since ASIC cannot rely on the declaration made on 19th July 2006, thus ASIC has to prove its allegation on the basis of the resolution that was passed on 22nd August 2006, that the trial judge was erred in concluding that the passing of the resolution 22nd of August 2006 has resulted in any kind of contraventions. The directors has taken into account various matters before the passing of 22nd August 2006 resolution. Adequate consideration are given by the directors before any resolution is passed. 19 July 2006, the court held that constitution that was amended on 22nd August 2006 was supported by the amendment that has already taken place on 19 July 2006. Reliance entity has the power to bring alteration to the constitution without asking the approval of the members as per section 601 GC of the Act. Thank you. And now I will pass to my fellow. He will discuss contravention of section 208.
Thank you, my friend. My name is Abdul Sami and my student ID is EMV21288. I'm going to discuss the contravention of section 208. An approval is required from the member of any financial benefit such as approval was taken by the directors. Section 2083 is also not applicable. The court held that there is changes are brought in the constitution as per which listing fee is permitted to pay, and thus the directors were capable to make such payments. There is no contravention of section 208. Now, before concluding our presentation, we would like to discuss few other things. Where possible and applicable on the relevance of the decision to development of Australian corporation law or the impact of the decision on the operation of companies in Australia. A narrow approach that is taken upon the Reliance entity powers and the concept of section 601 GC1 B as analysed in 360 Capital RE Limited versus Watts 2012 is a better approach in comparison with the approach that is taken in the Barrett in ING Funds Management Limited versus ANZ Nominees Limited 2009. Once a scheme of constitution is amendment and are lodged to ASIC, then such lodgement will have legal effects unless until the same is set aside. The amendments that are made are considered to the basics upon which the directors are held to authorize to make their decisions. The distinction is made amid the approach that is taken by the court while imposing civil penalties from the approach where there is breach of rights of the members which involves criminal penalties. This is all for today. Thank you.